Hi, everyone. Harry here to talk about the response from Lindsey Halligan to the hearing I attended yesterday, at which Judge Nachmanoff seemed disposed to believe Comey's version of events and his legal position that he had been the very, very rare criminal defendant in the federal system whose whole indictment is a violation of the Due Process Clause and the First Amendment because it's flat out reprisal from Donald Trump. And the argument by Lindsey Halligan, she actually didn't make it. There was a colleague, they couldn't even find anybody in the Eastern District of Virginia, but they dragged somebody in from, I think, South Carolina. And the argument was, oh, it wasn't really. Yes, he might have made those statements to Donald Trump, but it's the grand jury that decided here and Lindsey Halligan that decided here. And that did not work out very well because Nachmanoff was able to establish in questioning. She got there a couple days before she went in. How did she independently figure all this out in just a couple days? And she had to act quick because of the statute of limitations. And the attorney really was sort of shuffling on his feet a couple times, asked for time to check with Halligan and his colleague from South Carolina. And at a certain point, Nachmanoff said, Ms. Halligan, your counsel of record here, and made her come to the podium and confirm what was the headline from yesterday with this stunning moment that it turns out, little problem. The actual indictment of Comey was never presented to the grand jury that ostensibly returned it. I've talked about that at real length, and my Substack is on that hearing yesterday. The fallout from there is not complete, but let's move on to the response from Halligan. And this is just so, Trumpian and just completely characteristic. At a certain point in the hearing, when Comey's attorney, Michael Dreeben, a very respected, very appellate kind of guy, very soft-spoken, etc., Nachmanoff trying to zero in on what his position was. So are you saying, for lack of a better word, that Halligan is like a stalking horse or a puppet for the president? In other words, even though she signs the indictment, she's acting, and the but-for cause of why she's doing it is the president's command expressed many ways, including in that infamous Truth Social posting that was apparently supposed to be an email to Pam Bondi. And Dreeben said, I don't want to characterize one way or another, but yes, she's certainly doing what the president ordered. And they tried to say on the other side, unpersuasively, no, just her own independent judgment, a woman who has never been a federal prosecutor for a minute, who, wouldn't know the legal standards. Remember, to make an independent judgment. And Nachmanoff brought this up, and what Nachmanoff brought up is the principles of federal prosecution say you can't do it unless you decided the person's guilty, and you're probably going to get a conviction. Nachmanoff practiced in that district as a defense attorney. I had some dealings with him. He knows what he's talking about. And what was the DOJ lawyer going to say? Oh, no, that doesn't apply anymore. The president and Bondi said no. So he had to acknowledge that if the real causal reason was Trump, and his order, that would be a violation. Okay, they leave the hearing, and in just classic form, Halligan gives an interview to one conservative outlet only, the New York Post, and in it, she, it's so Trumpian, from Kavanaugh to just that sort of outrage that's completely frothed up out of nothing. Her big complaint to the New York Post He called me a puppet, and how dare he? And I'm just about the facts of the law, but she takes Nachmanoff to task and reads the whole code of judicial, somebody gives her the code of judicial canon for how he was supposed to be at a hearing, which, by the way, describes him to a T. I was there. He was soft-spoken, calm, respectful, maybe in that one moment where it turned out that the grand jury hadn't even seen the indictment in question. There was a little bit of a, almost wince on Nachmanoff's part, while everyone else in the audience was like swooning and having this kind of, what the hell did we just hear? But he was impeccable, really impeccable, and, thoughtful, conscientious. He could have, in fact, dismissed the case from the bench, said that the issues are too weighty, etc. So it's just total bullshit for conservative consumption only, that she would then come out after and accuse him dishonestly, disingenuously, of calling her a puppet. Okay, so that's her response. Now, then the department issued a big brief at 5 p.m. last night. That was already required because a couple days ago, and I think you guys remember this, you had this long 24-page, really, really tough on the Department of Justice opinion by Nachmanoff's magistrate, the person, he's a judge, but who helps him, sort of work the discovery issues, etc. And he marched through and found 11 instances, not even counting this one that came out. The one that came up yesterday, he adverted to it, but said we'd be in total uncharted territory. And, it was just at the time a mystery solved. We're in totally uncharted territory. But in addition to that, there are 11 separate instances of real misconduct, mainly on Halligan's part. And the order that he gave, this is the magistrate, was to release all the grand jury transcripts so the defense could have them and they could argue about possible remedy here, including dismissal. The department responded to that yesterday at 5, and they basically said again and again and again, with a couple instances, a couple times they disputed the facts, but mainly they just said, that's not a reason to dismiss. That's a clerical error. Forget about this. So it really was a kind of even if sort of response. And on the main discovery that we learned, the gobsmacking moment at the hearing, Nachmanoff proffered a case for the parties to think about that in fact does give some basis for the government to say, yeah, I know we really screwed it up, but you can't dismiss for that reason because you should find this is what the grand jury actually intended. We'll see how that goes. But more serious is first, the vindictive or selective prosecution motion itself, which I think would surely be with prejudice, and that was going very much in Dreeben and Comey's direction. Then all of a sudden we had this, toward the end of the hearing, crazy lurch into uncharted territory, but that doesn't change the bottom line. So that looks very serious to me. Even more serious, the magistrate judge found a couple incredible blunders and not sub-rookie mistakes by Halligan in how she handled questions from the grand jury. He didn't quote it, and we may see the quotes now because Nachmanoff may well order the release of the transcript. But one seemed to suggest to the grand juror who asked it that Comey has a sort of burden of proof, and if he doesn't testify, that could be held against him. So textbook violation of the right to counsel and the right not to testify against oneself. And then, in response to another question, seemed to say, well, if this, all seems a little thin to you, there's other evidence out there we'll produce at trial. So axiomatic, a grand jury can return an indictment only based on the facts that they hear and the prosecutor presents. So that's one in which the department's response, I thought, was really telling. It basically just said you can evaluate this under a harmless error standard, even if she said these things. And of course, they know now she said these things. In fact, Pam Bondi said she reviewed the transcript and everything is copacetic. I think Bondi will be in the hot seat somewhat to have green-lighted this after seeing these flagrant errors. But if the inquiry is, as the U.S. says in this paper last night, was it harmless beyond a reasonable doubt? You're talking about a 3-count indictment. They turned down one, and the other 2 reportedly are very close margins. And these statements are so flagrantly misleading and grave that I think it's very hard to see how any kind of neutral decision maker could say harmless beyond a reasonable doubt. So of all the stuff that's emerged, and we're up to an even dozen of serious flagrant misbehavior by the government, mostly by Halligan, these misstatements by her, so basic. And, I've talked about this from the start. She not only doesn't know the first thing about going in a grand jury, she is, under political marching orders to bring Trump the heads of Comey and James and now maybe others. So that's just the perfect recipe for overreach and misstating. A grand juror says something that indicates the grand juror is on the fence. She's just looking to, paper it over and fast. And remember, we're at the last couple days before the Comey statute of limitation even runs. So it's very plausible that she said these very grave misstatements. And I think if she did, and they know the department, so I think it's telling that all they said was harmless error. The harmless error analysis is very likely to go against the government. So we have this pratfall from yesterday, where, as I said in my Substack, she's had egg on her face to date. This was more like a whole omelet. That might not be the thing that actually brings the case down, and I think the case is coming down. We'll see. But we have, remember, the Judge Curry motion to say she wasn't qualified. That Judge Curry is going to decide by next Thursday. And now at least 2, it seems to me, serious possibilities for Nachmanoff to dismiss with prejudice the selective vindictive prosecution itself, and then the misstatements in the grand jury, which I think will be very hard to see to just excuse as harmless under the circumstances. So those point really squarely, that one points really squarely at Halligan. The vindictive prosecution points very squarely at Trump and Bondi, and the other one in Judge Curry's court sort of points to the whole DOJ apparatus. So everyone is on the hot seat here, and we'll see who actually winds up being the cause of a dismissal. But I think a dismissal is coming, and much deserved, because, as I've said, this is, in my opinion, the worst single action the Department of Justice has ever undertaken. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.